burden. Well, they do have a burden, as you've pointed out, to prove to defend their case, and if they thought that there was going to be some sort of conflict, which they admittedly said there wasn't any surprise, then they had a requirement to get a tiebreaker, and that's to proceed with an EMA. Claimant got the deposition to prove her case. That's different than proving the need for an EMA. It's not. It wasn't required of claimant, and claimant did take the deposition.
And when was the deposition again?
Oh, I think the deposition was it the end of January or the beginning of February? The report, I think, is, I don't really know, but I think the deposition was February 4. Is that when you all received it or something like that?
The exact date is not real critical. My question really goes to, you would concede, I take it, that they did act with reasonable promptness as soon as the deposition was complete.
I think about a week after they had the deposition.
You concede that's reasonable promptness?
I would think a week after you receive the deposition, but that's assuming that they weren't on notice prior to the deposition, which I'm not conceding.
I'm not asking you to concede your case. I'm just asking you to concede, and apparently you do, that as soon as they got the deposition, they act reasonably promptly.
I think a week is, that was, and I don't think that that's what the JC, and that's not what the JCC found. They said if you were going to file this motion, you needed to do it sometime before last week or this week. That's what he said. So the JCC found that the deposition was not what provided reasonable notice of the conflict. The JCC implicitly found that it was the report attached to the PDF because he said PFB, because he said you needed to file it a week or before last week. I think that EC's argument is essentially that you all need to create a blanket rule that any time there's an EMA, a conflict, that the JCC has no discretion but to appoint an EMA, regardless of what that would do to the timing of the trial.
Well, that's what the statute says, right?
Well, the statute says they must, but the case law says that you look at the timeliness of the request, and I also
but the statute doesn't say anything about timeliness, does it?
The statute says in 440.25B, I think it is, there's a provision in there about continuances, and it says once the hearing's set, then any continuance can only be granted on a showing of good cause. And I think that when you read the must appoint an EMA with the timing of a trial and the fact that continuances should only be granted upon a showing of good cause, why you could not have discovered this or why you could not have done something to fix this sooner, that all supports this court's case law that says you have to look at the promptness, the reasonable promptness of the request. I don't think it's contrary to the statute, and I think that if you adopt a blanket rule that says that, then you'll have to be going in bank, I would say, to deal with the Cabrera and all the other cases that talk about reasonable promptness. I think that Cabrera and those cases have resolved the issue of the timing by saying it's got to be reasonable promptness. And I think that that's exactly what the problem is. Here, this woman had been injured 2 years before the hearing, and her case had gone on for 2 years. And on the eve of her hearing, the day before her hearing, they're arguing whether there should be an EMA, which would necessarily cause
but the report,
another continuance.
In fairness, the first time they're notified in any way is approximately 2 months before they move for an EMA.
Well,
that's 60 days.
The production of evidence, and if you want to, and the report was, we can't dispute that. The facts are what they are. But, I think the petition for compensability was filed in July after
I understand that, but if we rule in your favor and announce a rule or a decision along those lines, then 60 days is unreasonable to wait, right? To wait 60 days to sit on your right to ask for an EMA for 60 days. Take it outside of the context when the date of the hearing is. Since your client didn't provide the report until December the 8th, then 60 days, do you think is unreasonable?
I think 60 days is unreasonable. I think most things in the legal world kind of revolve around 30 days if you wanted to say what's the outside rule if you have to craft one. I don't think you have to craft a rule. In fact, the case law that already exists doesn't craft a black letter rule, which is what
This is reasonableness.
this is reasonableness, and I think that that's a circumstances. You know, there could be, and the cases point to that there could have been discovery violations, there could have been pretrial stipulation problems, there could have been a claimant who refused to go to an IME, which is one of those cases. There could be a host of reasons why there's a delay in discovering the conflict that's not attributable to the EC or to the party requesting the EMA. And those are all the circumstances that we're going to let a JCC who's in charge of trying a case and controlling his or her docket decide based upon the circumstances here. And admittedly, EC says we weren't surprised by the deposition. They knew when the report was there that this guy was going to say major contributing causes up and down from all the chairs. They knew that. And they decided that what they were going to do was get their own IME, and they were going to see what he said. And then when their IME, you know, yeah, he thinks that she's got, a degenerative joint disease in her knee, and you know, but he really thinks that's her overwhelming problem and that she needs a total knee replacement, when that's not what she's asking for. She's asking for repair of a torn meniscus. And he gets a little testy in his deposition. I know EC and I disagree about what he said, but I think if y'all haven't read it, I invite you to read his deposition. That overwhelmingly, that's what he's saying. She's got degenerative joint disease, which requires a total knee replacement, and that's not what claimant's asking for. She's only asking for repair of a torn meniscus. So, I don't think that that's, under the facts of this case, that when the JCC looked at all of the facts in this case, that this court can say it was unreasonable, that no JCC would have come to the conclusion that the motion made here 8 days before trial, one day before.
Is it your position that Dr. Furer's report at least placed the EC on notice that they should do something further? In other words, take Dr. Furer's deposition?
Exactly. Exactly. Under the circumstances of this case, I don't see how you could look at it any other way. And as I said, the EC has said they weren't surprised by the deposition testimony. So they knew. That's a concession that 60 days out that they knew, essentially. I think that the other thing that I want to comment about the case is that, the case law that the EC has relied on its briefs is that they're all factually distinct. The ones that talk about this black law that the JCC must appoint an EMA are all dealing with situations in which timeliness isn't an issue. And those cases, it's always nice to adopt a black letter law that would resolve everything, but those cases are factually distinguishable from this one where timeliness is the issue. And I submit when you look at the cases that discuss timeliness and you look at the facts and the circumstances of this case, that you should affirm the JCC's finding that this was an untimely motion and affirm the order. And unless you have any other questions, I'll just simply ask you to affirm. Thank you.
Mr. Foreman, you've got 2 minutes.
May it please the Court.
Counsel, why didn't Dr. Furer's report at least put you on notice that you should have taken his deposition?
Your Honor, I don't have an answer for that.
You didn't take his deposition, did you?
We didn't set it. We cross-examined him.
Claimant.
Right. Yeah. During the course of the proceedings where we received the report in advance of the final hearing, it was the claimant that scheduled the deposition, which I think, as a practical matter, I'm not certain how the progression of facts and the chronology of this would have changed had we noticed the deposition, since the claimant had already noticed it anyway.
Isn't the most logical conclusion from the events here that you didn't set, by you, I mean your client, didn't set Dr. Fiore's deposition because your client knew what he was going to say? You didn't feel you needed to set his deposition.
I would agree with that. We didn't feel it was our obligation to depose the other side's retained expert.
You only do that if you don't know what they're going to say.
I think the only reason you would do that is if you believe they're going to give you testimony that's favorable to your case. Otherwise, it's not effective advocacy for your client.
Because as a normal matter, and And deposing IMEs is different from deposing the normal witness in a civil case, for instance, because the IME is there for a reason,
Sure.
to provide the necessary testimony to support either party's position.
Right. But respectfully, Judge, Your Honor, I would contend our expectation and the existence of an actual opinion on causation are two different things. For example, even in the paragraph 10 of Judge Murphy's report, where he makes a clear finding of fact, it was the opinion of Dr. Fiore that major contributing cause exists. I mean, that had to have been in reliance on his testimony, not the IME report. I would even contend under the CSC standard of review, I don't know that that report would have constituted competent substantial evidence, on which to support a specific finding of fact like that. It looks like I am out of time, so I'll thank you, Your Honors.
Thank you both.